for delivery of judgment, WP Criminal 76/2025.
Wow, wow. Even if there were no money, but yes, and seriously.
Found the principles and issues determined by the orders of Supreme Court, as well as by the Honorable Gauhati High Court. As discussed here and before, this court is of the considered opinion that the state respondent has violated the mandates of Article 22(5) of the Constitution of India, as well as the principles laid down by the Honorable Supreme Court in instant case, while passing and executing the detention order of the petitioner. Consequently, the impugned detention order dated 7/10/2025 issued by the Commissioner of Police Guwahati, the grounds of detention served upon the petitioner on 8/10/2025, as well as the order bearing memo number so and so dated 14/10/2025, whereby the detention order of the petitioner was approved by the Governor, Honorable Governor of Assam, are hereby set aside and quashed. Accordingly, having held that the detention of the petitioner is bad under the law, and on quashing the impugned orders as well as the grounds of detention, the petitioner is directed to be set at liberty immediately, if not otherwise wanted in another case. In the aforesaid terms, the instant petition is disposed of as allowed.
Deeply observed.
Item 1, Contempt Case Criminal Sumoto 1/2025.
May it please. Lord, I've been requested to appear in this case, my lord. I'll respectfully pray, my lord. Of course, the person concerned will tender unconditional apology. Only thing is, we need to file a affidavit. I may pray for some time.
Mr. Choti, we don't know whether you have been informed or not. The respondent is under suspended
I've
sentence.
seen it. I've seen it, man. Very serious matter.
That we considering the everything overall, the age and all, everything is put it under suspension. But it's a case of almost
Well, I-
committing to the judicial officers.
No, I have gone through the order where from itself it is evident that there was already an order.
The affidavit will be within how much time?
2 weeks time.
But we are not dispensing with the personal appearance.
Yes.
My lordship. But if your lordship go by the procedure, Gauhati High Court rules, it's a criminal person. So he has to file an application for bail, my lord.
From your prayer, we give you time.
Yes.
So take a prayer, make a prayer for both. You are right.
Actually, he reached very late yesterday, my lord.
No, it's
Just-
okay, but you are right.
I've seen one, that's why I'm pointing out. Criminal. So he paid for some payment.
Correct.
Mr. E.J. Monta, done at senior counsel, and the senior standing counsel for the high, and standing counsel for the high court.
Mr. Chaudhary,
Milord.
first and foremost, as there is already a suspended sentence, first he has to file an affidavit putting his unconditional apology,
Yes.
then only we can permit him to file a affidavit. It is not like a civil contempt by which he can purge his contempt there in that affidavit. First, he has to, more particularly when he has a
Milord,
suspended sentence,
Milord will give a short date, Milord, we'll file that.
then only we can have
Yes,
it.
yes.
Looking into that, then we can proceed.
Milord.
Suggested date.
In that case, Lordship will have it on Milord, 1 week time, Milord.
Suggested date.
I'm sorry.
Okay.
It can be on. Huh? Could it be on 6th of March, Milord? I'm taking Aswas. Okay, so I take it with that. No,
Mr.
What is it?
K. Chaudhary, learned senior counsel. Along with Mr. DJ. Counsel appearance for the respondent. The respondent is also present. Mr. Howard, no application for bail has been filed. And no affidavit has been filed by the respondent to purge of the content. Next, Mr. The learned senior counsel appearing for the respondent pays for some time to make an application for bail and file an affidavit for purging the content. If thereafter, leave can be granted to the respondent to provide this response to the content petition. Next, yes. HT, in the meanwhile, shall tag the records of contempt case within bracket suo motu, that it was 1 of 2022. While listing the matter next. Next. Yes. Paid for by the senior counsel for the respondent. List the matter on 6/3/2026. Just before that you say, it may be, it is clarified that the personal appearance of the petitioner is not. I'm sorry, respondent, did not be expressed.
May it be the lawsuit. But with regard to the item number 10, my lord, if your lawsuit pleases, my lord, can it be taken up on Monday or Tuesday, my lord?
2017 matter.
17th matter, my lord.
Ask somebody to be here without looking at the record. We are not adjourning all matters.
My lord.
Just wait for some time.
My lord.
May I please, Lordship?
Ask someone to make a mention if you have some other work.
My lord, my lord.
I'd like to mention item number 3, specifically adjourned for the day.
3.
Yes.
Both sides are represented. The prayer made by one counsel for the petitioner. List on, his date, 2 weeks. Yes, you give your date after some time.
Wait, please, also. I beg to mention item number 14, my lord. The matter may be adjourned for 2 weeks, my lord.
What is this IA for?
Delay condonation petition, my lord.
Then why you are seeking time here?
Actually, my lord, there are some subsequent development. Department may withdraw this appeal, my lord. So we are waiting for that instruction, my lord.
Because you see, you will be taking a risk of adding this based on the delay.
Sorry, my lord.
You'll be taking a risk for adding those days in the delay. That's right.
There's subsequent some.
Because no, this is already, I think, more than 6 months.
Yes, my lord.
Filed sometime in August, September.
Yes, due to unavailability of bench, my lord, it was not listed. And one more, my lord, because some subsequent development have been taken place, my lord. So they may withdraw the appeal, my lord.
on the prayer made by Mr. N.J. Khatanir and now standing for the School Education Department.
School Education Department.
The matter stands adjourned today. Is property. This application is an old pending matter. Prayer for adjournment shall not be considered on the next date of this hearing. List on when
After 2 weeks, Malad.
you date after 2 weeks.
Yeah, then.
Obliged, Lordship.
Item 1 for motion.
May it please the Lord. But in this case, the opinion of the learned Honours Tribunal is challenged, my lord. But there are two basic grounds, my lord. One is that, my lord, the relationship between the petitioner and her father, who deposed as DW2, my lords, before the tribunal, that was disbelieved, my lord, by the learned tribunal. Now,
Just a moment.
Lord,
Which page is that opinion?
Lord, opinion is at page 52. my lords. Starts at page 52.
Who is Muslim Uddin?
Muslimuddin, alias Muslim Ali, is my father, and he appeared as DW2, my lords, in the learned tribunal.
Do you have any voters list with you and your projected father?
Yes, my lord, there was a voter list which, my lord, is of 1997, and it was annexed, and it is at the page 26. my lord. This is of the year 1997. my lord.
No, this is not an exhibited document. Out of the exhibited exhibit B.
Yeah,
Okay.
yes, this was
B.
exhibited. my lord. Only
Exhibit
4
B.
documents were exhibited.
Exhibit B, page 27.
This is the list, my lord, and this is from the village of Kuru Kani of Mouza Goruimari, Tezpur. This Muslim Ali is son of Sabir. my lord. Muslim Ali alias Muslimuddin, who deposed as DW2. He is the son of Sabir. And I am, my lord, Sahira Khatun, daughter of Muslim Ali.
And which page is your written statement?
Written statement, my lords, is that look, 30 is my evidence, and written argument is at page 36. my lord.
WS at page?
So evidence at page 30. my lords.
No, WS.
WS, my lord, I'm not given a copy of the WS, my lord. This I've got the evidence and the written argument that was. Lordship. DW1, DW1 is at page 31. I'm myself the DW1. Lordship.
What has happened here? This is your written statement. You are sending it. You have flagged it. It is at page 43 of the transport records. Now, in this record, you don't say that you were given an adoption to
Lordship.
somebody else. Now, when it comes to your evidence of DW1, then you say that at 7 years of age, you were given an adoption to somebody.
Yes, that is
His
there
name
in the
I
evidence.
forgot, Sher Alam. Correct.
Lordship.
If we don't know, you'll have to tell us from the principles of Mohammedan law if there is a concept
No,
of
there is not.
adoption in Mohammedan law.
No,
I
there
am
is
not
not.
aware of it.
Muslim law only has a system of kafala, my lords, which is
We
a
don't know.
sort
We're
of.
just telling you. After that, what has happened? 7 years you were given an adoption, but everywhere you use your name as name of your what you call your now if I may use the term blood father.
Lordship.
Now, how can if you are given in adoption, how can you change to your previous father?
Because, my lord, for the reason that, my lord, as your lordship says, there is no, the Muslim religion doesn't recognize, my lord, adoption. In
But
other
then-
words, my lord, she was staying at the house, my lord, and performing domestic works. That we have said. And the person who, my lord, to whom she was given in adoption, he has also
Then
deposed
your
that.
father changes and you don't have, then you don't have your link with your father.
No, my lord, that, but
You don't have a
here in
link
this case,
of
my lord,
adoption.
my linkage will have to go back to my blood father only. Adoption
No.
cannot, my lord.
Once you say adoption, that means you sever your link with your previous father.
No, let
And
me
if
say
you have
this, my
not
lord.
created a document,
No, there is no document. No document filed to show adoption. The only the difficulty is that, my lord, since she was given away basically for working as a domestic help in somebody's work, her village is at Korokani in Goroimari, which is a place in Tezpur. Now she shifted to Cotton Road, where this DW3 used to reside. He was a prominent citizen of the town, my lord, and basically she was working as a housemaid. My lord. Let me say, this adoption argument has been taken only to give a color of. But I am not claiming anything from my adopted parents. I am claiming from Muslim Uddin.
no. In your evidence, when you relinquish your father,
Lordship.
it was nobody's case. You yourself in your evidence relinquished your father.
A relinquishment, in fact, I cannot, because the religion itself does not permit this.
It's your affidavit.
No, that I cannot improve the case what is already there. But the fact remains that, my lord, the petitioner has never described herself as the daughter of the DW3. She has always said that I am the daughter of Muslim Uddin only. Every document, even prior to the tribunal, shows her as the daughter of Muslim Ali. And that is why Muslim Ali comes to the court, says that I have 12 children, and because of poverty, I have given this girl in adoption. And the only thing was that, my lord,
What is that's what is there? What do you mean when you say that you've been legally adopted?
But let me go so far as to say, my lord, that I am saying what was the truth, my lord. I could have said that no, I have been staying there. But the point is that, my lord, because my subsequent voter IDs were from Tezpur. So I was voting in Tezpur. That is also what weighed in the mind of the learned tribunal, that you were born there, but why were you voting here? That is the argument. Now, the question is that, because I was not at all staying with my family. I was not staying with my family. I was given away because he has so many children. He gave away, and she was working as a housemaid. These are literate people, and they do not. But I have never claimed on the basis of that I am the daughter of DW3. So, this adoption argument, is perhaps neither here nor there. I am not claiming any benefit on the ground of adoption. Only to explain that why have I been voting? Because this person, I have said that DW3 was a commissioner of that area. So, and that is why the electoral roll also that in fact was exhibited. That roll, Lordship will find at page 28. The Lordship comes for a minute. 29 months. The annexure 9. This was exhibited, Malud. The voter list of 2014, which is prior to the proceeding before the tribunal. The Lordship comes to page 29 and the serial number 261.
Is it an exhibited document?
Yes, it is exhibited. In fact, Malud, in the evidence, there are two numerical mistakes. One is in the year of 1997, it's written 92. And this electoral roll has been written as 2016, but actually it is 2014. Voter Talikat 2014 Annexure 9. Should be Annexure 2, 3 or C. Is Exhibit 2.1.
The scientific records.
Good. Right. We exhibit C now. But fact remains that, my lord, the evidence could have been better presented, documents could have been properly filed. That aspect is there. Lord. Lord, one aspect is that, my lord, the finding of the learned tribunal at paragraph 7, my lord, is that six in fact, my lord, that none of the witnesses divulged anything about the other family members. Now but the specific question was put by the tribunal itself, and then he has answered, DW2 has answered. Lordship. Yes. Yes. But that is true, my lord, because only 4 documents were exhibited. And in fact, the WS is also appears to be silent on that part. 66. Lordship. Lordship. Well, that is a, Lord, even the Honorable Chief Minister is also called as Mama Mandir. That is a different aspect of the matter. Yes, my lord. My lord, because my lord, when the religion prohibits, my lord, adoption, I cannot, my lord, call somebody else just because it is one of the pillars of the religion, my lord, that there is no system of adoption in the religion itself. So I cannot be given in adoption legally, my lord. So that is why. Lord, it's a very similar. But Exhibit D, my voter card in which my father's name has been reflected, that was not even considered, my lord, by the learned tribunal. The learned tribunal stops its examination at Exhibit C. If your lordship will kindly have paragraph 8, my lord. No, only to prove that, my lord, these documents are not, my lord, procured after the proceeding started, because the voter card, the EPIC card, which was exhibited as Exhibit D, that, my lord, shows that my father's name is Masule Ali. That document is there, my lord, that page 24, and it was Exhibit D, my lord. That was not even taken into consideration because this EPIC card is of 2013. And I have not claimed that I am from that village now. I have always claimed that yes, I was adopted, I was given in adoption. Subsequently, I married a person who turned out to be mentally disabled. And then this. So this is 2013. But this document was not taken into consideration by the learned tribunal. Learned tribunal stops at Exhibit C and doesn't go further. Because learned tribunal comes to a finding that I have not mentioned my mother's name. So I am not the daughter of Muslim Ali and Sakina. But I have not said that my mother is Sakina. I have said in my evidence that in my cross-examination that my mother's name is Nurjan Nisa. And it is this Muslim Uddin, whether the Muslim Uddin of 1966, son of Sabed, and the person who came to the court as DW are one and the same person. That is the crux of the issue. That aspect, the learned tribunal, in my humble submission, is not considered. Learned tribunal has shifted its gaze towards the mother. But in no document of that time, the mother's name used to be reflected. Even if I had any document. If any document exists, that would be a procured document. So, my lord, these people have produced whatever they could. And 2013, the voter card it predates the, my lord's, proceedings. 1997, the electoral roll, yes, my lord, 30-year gap is there. But the fact remains that, my lord, I have I can only show my name in the roll because I have become major only at that point of time. So I cannot show my name in the roll along with my father and the mother after the before my age of majority. So that is why that is the gap. That is Morjan Nisa. And Morjan Nisa's name is there, Malod, in 1966, that which is exhibit B, Malod. The electoral roll, Malods, of 1966 of the village Kurukani. And the age of the persons also more or less matches, Malod, because Muslimuddin, son of Sabed, is shown to be around 35 years of age. So the Lordship considers that aspect. He would be 85, 86, which is roughly the age that he appeared before the learned tribunal. Now he has passed away. Well, one more aspect before my learned friend starts. The learned tribunal has also considered, has given the finding that I have come from the specified territory of Bangladesh post 1971. But my lord, in the interrogation report, my lord, which was there, it only says post 1971, post 24/3/1971. It does not refer to any territory, country of origin, nothing is mentioned. For a minute, if your lordship will have the on the record, my lord, this interrogation report, which is the basis of the reference. Page 42. Well, it's 1997 voter list. Lordship. Yes, 1997. Here, my lords, my father's name and one brother and my father's second wife. Thousand 16 voter list followed in that page. 29 minutes. Yes, 261 minutes. Serial number 261, Sahara Begum, and here also, my lord, I have used my father's name only, Muslim name. Lord. That serial number 248 of this list, my lord, the DW3 is there, who is my adopted, you know, Murjan Nisam. Yes. Lordship. No. And later she passed away and married second time. No, DW2 only mentioned the name of these children. But Tribunal has given the direction that I should be pushed back to the specified territory of Bangladesh. That is, my lord, beyond the terms of the reference, because the reference was only regarding whether I'm a foreigner or not. There is no presumption, my lord, that I am from the specified territory. I cannot be pushed back to Bangladesh. To that extent, my lord, also the learned tribunal's opinion is erroneous. Because nowhere does the reference order say anything.
Yes, Lordship, here in this case, Lordship, proceeding has exhibited only three documents, proceeding. Yes, Lordship, if we exclude voter ID, yes, Lordship, and EPIC is Lordship, already regarding EPIC Lordship, already this law has been settled by this honorable court. What in Babul Islam case, it is observed that Lordship in para 20.2 Lordship. Babul Islam 3 WPC 3547 MD full stop BABUL ISLM para 20.2 Lordship, this Lordship reported Lordship reported in perhaps it is reported case Lordship, but that reported number is not with me Lordship.
WPC?
Regard Lordship WPC Lordship 3547
Or
2016
16?
16
Yes.
3547 decided on 3547 of
Dated
2000
order?
95 2018 95 2018 para 20.2 honorable court observed that Lordship in so far exhibit number 7 elector photo identity card is concerned, besides not being proof, it is a post 71 document. Besides, merely producing such an identity card in the absence of supporting evidence would not be proof of citizenship. Lordship, it was observed by this honorable court.
That's one part, non-discussion is another part.
Lordship. And regarding Lordship, these exhibited documents, the proceeding concerned has never exhibited any document, Lordship. Only his father has exhibited this, projected father has exhibited these documents, Lordship. Not a single document has been placed by him,
No,
Lordship.
no, no. DW1 did it, page 31. It examines on the documents. Page 31 is fine. 30 it starts, 31 down below is the following documents.
Yes, but I am reading from page, Lordship 44, Lordship. মই মোৰ জন্মৰ কোনো প্ৰমাণ পত্ৰ এই গোচৰত দাখিল কৰা নাই। মোৰ দেউতাৰ স্থায়ী বাসিন্দাৰ সম্পৰ্কত মাটি বাৰী আদিৰ তথ্য এই গোচৰত দাখিল কৰা নাই। মুছলিম আলী আৰু মুছলিম উদ্দিন দুয়োটাই মোৰ দেউতাৰ নাম হিচাপে শপতনামা বা অন্য কোনো তথ্য দাখিল কৰা নাই। 1966 চন আৰু 1997 চনৰ মাজৰ মোৰ দেউতাৰ নাম থকা কোনো ভোটাৰ তালিকা গোচৰত দিয়া নাই। মই ভোটাৰ তালিকাৰ মই শ্বেৰ আলমৰ এজন তুলনীয়া ছোৱালী হিচাপে কোনো আইনী নথি দাখিল কৰা নাই। মোৰ লিখিত বৰ্ণনা আৰু সাক্ষ্যত মোৰ ককাই ভাই ভনী আদিৰ কোনো বৰ্ণনা দিয়া নাই। মোৰ সাক্ষ্যত মোৰ নাম উল্লেখ কৰা নাই আৰু মোৰ নামৰ কোনো তথ্য দাখিল কৰা নাই। মই মুছলিম আলীৰ ছোৱালী হিচাপে কোনো তথ্য দাখিল কৰাৰ কোনো কথা মোৰ সাক্ষ্যত কোৱা নাই। মোৰ নামৰ জমা দিয়া ভোটাৰ পৰিচয় পত্ৰৰ আইনী ভিত্তি আছে নে নাই মই নাজানো। মই বিয়াৰ পিছত ঘৰৰ পৰা ভোট দিয়া নাই। স্বামীৰ ঘৰৰ পৰা ভোট দিয়া নাই। মই তেজপুৰ নগৰৰ ৱাৰ্ড নাম 2 ভোট।
Translation is I think wrong somewhere.
Yes, yes. উক্ত স্থানত
We tried to do it, Malad, to the best, but as your lordship sees, Malad, the writing is very difficult to decipher. Some of the places we will stand corrected if there is any error, but Could be only because of the quality of the writing that is.
So as per his cross-examination lordship, her cross-examination lordship, he never submitted any document. And lordship, apart from that, lordship from 1966 to 1997, lordship, there is a huge gap, lordship. There is a lack of continuous stay of the projected father of the petitioner. Apart from oral statement, lordship, there is nothing in this record, lordship, to prove her citizenship or prove her relationship with projected father whose name appeared in the voter list of 1966. And lordship, tribunal has already discussed all these things, lordship. From para 6, page 54, I am reading, lordship. From the said document, it may be ascertained that the proceeding, namely Sahara Khatun, is the daughter of Muslim Ali, and Sakina Khatun is the wife of Muslim Ali of village Korokani. But from the perusal of both the above mentioned documents, it is seen that in the exhibit A, the name of wife of Muslim Uddin, son of Sabed, is shown as Murjan Nasa, and in the exhibit B, the name of the wife of Muslim Ali is shown as para 6, page 54.
Exhibit A, Muslimuddin Marjan.
Para 6, lordship. Then lordship,
Just now. Then it was. Yes.
so lordship, then lordship, then page 55, lordship, all the above named witnesses have deposed that the proceeding is the daughter of Muslimuddin alias Muslim Ali, who was abducted by DW3, but none of the witnesses has deposed anything regarding other family members of either of the proceedee or her father. The proceedee has nowhere stated that her father has two wives, namely Murjan Nessa and Sakina Khatun. The proceedee has also not stated that Murjan Nessa and Sakina Khatun both are the names of her mother. Hence, it is not proved that Murjan Nessa and Sakina Khatun are names of the same lady. That is mean to the mother of the proceedee. It is also not proved that Muslim Uddin, the husband of Murjan Nessa, and Muslim Ali, the husband of Sakina Khatun, is the same and one person. From the above discussion, it may be believed that the proceedee is the daughter of Muslim Ali and Sakina Khatun, whose names are recorded in the book, but recorded as voter in Exhibit B, that is electoral roll of 1997, but it is not proved that proceedee is daughter of Muslim Uddin and Murjan Nessa, whose names are recorded in the voter list of so and so. So, lordship, here also, if we see the voter list of 1966, lordship, and compare it with voter list of 1997, lordship, I think, lordship, both the persons are different persons, and proceedee could not able to prove that these persons are same person. Even if we accepted these persons are same person, then also proceedee is unable to establish her link with those persons, lordship. And lordship, regarding oral statement, lordship, in Vijayada's case, lordship, it was earlier settled the position, lordship. It is reported case 2018 3 GLT 118.
Please repeat again.
2018 1 GLT 118. 2018 3 GLT 118. Yes, Lordship, in WPC 562 of 2016. Para 17. I am relying, Lordship. It is tried that mere filing of written statement and oral testimony in a proceeding under the Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceedee by adducing documentary evidence which are admissible and relevant. So, Lordship, oral testimony or filing of written statement is not enough. Apart from that, Lordship, written statement, I think, Lordship, I have not seen the written statement, but I think, Lordship, from evidence part, what I have seen, Lordship, pleadings are not enough. What proceeding has pleaded, this is not enough to prove his citizenship. And one cannot go beyond pleadings, Lordship. And Lordship, even father's claims and deposed, Lordship, that also not acceptable in the eye of law. Regarding that, Lordship, in Asia Khatun's case, perhaps it is not reported, Lordship, I have to see. WPC 4020 of 2017. Decided on 21/11/2019. Asia Khatun ASIA, Asia KHATWN. WN. Para 7, Lordship, I am reading. The statement of DW2, that is Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in the absence of any document showing his relationship to the petitioner. In this, we would observe that proceeding under Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is solely insignificant. Oral testimony alone is no proof of citizenship. The evidence of DW2 does fall short of being considered as cogent, reliable, and admissible evidence, so much so to establish linkage of the petitioner to him. And Lordship, this Honorable Court has also discussed in respect of mother's evidence also, Lordship. It is reported case. This Honorable Court has also discussed in respect of mother's evidence also, Lordship. It is reported case, Lordship, 2020 3 GLT 347. In WBC 1900 of 2019, Noor Begum, NUR, Noor Begum, BGUM, Begum. Lordship, date of order is 18/2/2020. Lordship. Reported in 2023 GLT 347. Regarding oral evidence, Lordship, here mother come before the Honorable Tribunal to depose on behalf of her projected daughter. Para 6, I am reading. Statement of DW2, Zaharun Begum, who claimed to be the mother of the petitioner, cannot be relied upon in the absence of any documents showing her relationship either to the projected grandfather, father, or to the petitioner herself. Oral testimony DW2 alone, since any documentary support cannot be treated as sufficient to prove linkage or help the cause of the petitioner. Surprisingly, the petitioner failed to produce a single voter list in her name even until the age of 50 years. we would reiterate that proceeding under the Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship. Here also in this case, Lordship, except voter ID, Lordship, there is no document placed by the proceedee to prove her citizenship, Lordship. So, Lordship, my humble submission is that, Lordship, there is no infirmity in the opinion passed by the learned tribunal, Lordship. So, opinion may not be disturbed, Lordship.
Lord, just two small submissions. One is that, my Lord, every case is a decision is an authority on those particular facts. Lord, in this case, exhibit A, C, and D, the three electoral rolls and the voter ID card, I have shown that the name of my father. And all these three, my Lord, exhibits A, C, and D specifically, my Lord, it is not considered. They show my linkage with my father. That is the first submission. So, my Lord, they are different from those cases where, my Lord, not a single document could be produced showing the relationship between father-daughter or mother-daughter. And the second submission is that, my Lord, the reference was only based whether was clearly on the issue of whether I am a foreigner or not. Here, the tribunal has, my Lord, transgressed the reference, and it has gone on to hold that I am a foreigner from post 1971, and from the specified territory, I should be pushed back to the specified territory. That was not the subject matter of the reference. The tribunal, as your lordships know, my Lord, they are bound by the reference. It cannot, because there is not a single, my Lord, any material to show that I am from the specified territory. There is no presumption in law that I am from the specified territory. Because your lordship may consider the interrogation report come reference order, my Lord. There is nothing, my Lord. And if I may just read out, it only says, during inquiry, it appears that MST Sahara Begum, wife of Siddiq Ali, entered into India after 25 March 1971. She could not produce any documents in support of her nationality. So this case is submitted to the Honorable FT for opinion. That is this only limited reference. So it cannot be held that, my Lord, I am from the specified territory and I should be pushed back to Bangladesh. So the opinion, my Lord, is erroneous on those two counts, especially.
বাংলাদেশ লিটিগেন্টস অপিনিয়ন কথা বলি অর্ডার হিসাবে লব না আলাদা অপিনিয়ন হিসাবে লব এবার ক্যাম্পাস গেলে তো তাকে লিডি হয়ে যাচ্ছে এবার ক্যাম্পাস ঘরালে তো তাকে চলে গেলে কিন্তু বলতে পারছি opinion still to give that offline. Just to limit the difference. That is the foreigner of. Yes, we shall include open two party function department. That will be executive decision that cannot be made.
Published. Lordship. Lordship.
First order.
Jodhpur Jilla Arokhi Adhikar 3516. Lordship. Jodhpur Jilla Arokhi Adhikar পৰা অহা 6/4/16 তাৰিখৰ কি হয় Lordship. 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 Lord's finding and recommendation. Page 32 documents in support of her nationality. So this case is submitted this part. 3323. I'm sorry. Name and address of sister.
Yes.
Item 2 for motion.
Itu very clear. Only I have submitted only one copy, Lordship. Lordship. Regarding custodian of registration certificate, Lordship, seeking instruction regarding who is the custodian of the said certificate, Lordship. As per telephonic instruction, Lordship, concerned Deputy Commissioner is the custodian of said record, but my instruction said that that record is not available at the said office, Tinsukia district office. And Lordship, another aspect is that that person concerned is not no more. He died. That instruction was also provided, Lordship. Tinsukia definitely. No. Bukakan nama saya. Bukakan. Dokumen lah. What point you have? পুলিচে কৈছে তেওঁলোকে এইটো তিনচুকীয়াৰ হেৰি আছিলে ন চাব ডেপুটি কালেক্টৰ তিনচুকীয়ালৈ তেওঁলোকে লিখিলে তিনচুকীয়াত available নাই।
আগতে এটাই ডিস্ট্রিক্ট
আপোনাৰ তাত কি আছে বুলি কৈছে?
মোৰ তাতে এইটো কথা মই জইন আছে district of insurance, community of police, party in case no element depends on issue by the association. Association issue করা তো হয়, whether issued by association or not.
এখনো দি দিয়ক।
District. District issue. Okay, yes. District is very more, right?
Lordship, in this case, Lordship, a guy appears, she told me that some more time will require, Lordship. See, in the documents annexed, Lordship, there is in the writ petition, you will find page 22. It is there in the LCR also. Page 22 is the certificate of registration, Lordship. Lordship. This is the original document at page 46. In Target and send it to you. Not original, so approved in original. That means this document in original was produced before the tribunal.
Not. District collector, things will be.
Who is the custodian of this record?
Now we get it.
Now you've seen this document, it was put in original, therefore it was produced in original before the tribunal. Now, in the opinion, this was discarded. This is exhibit number 2.
Lordship.
Yeah.
Just a moment, this question has come up, just a moment. There's no three question.
You should get a. Yeah, question is exhibit one. This is the purpose. This is exhibit one. No, it will exhibit to A. We see. No, it will registration certificate. OBC to 1. 1 to 1 to 8. No, yes, it's just
Now you see, this Tinsukia and Dibrugarh were bifurcated in 1989.
89.
This, if you look at this document, this is at police station Digboi,
That's right.
correct? So far as my esteemed sister remembers, this Digboi would fall within the Tinsukia subdivision of erstwhile Tinsukia district,
Yes.
undivided Tinsukia district. So therefore, my esteemed sister believes that this document will not be in Tinsukia, it will be in Dibrugarh. Because if it is in 1960, then the district was undivided. Dibrugarh.
In 60, Lordship, I think it is Lakhimpur. At that time. Lakhimpur at that time.
No, whatever, but Lakhimpur. It's written here in the document. Also, you are right. It's CS Digboi Lakhimpur.
Lakhimpur.
Right. So it will go to that district.
Lakhimpur,
Your inquiries must be directed there.
Lakhimpur, Lakhimpur and Dhemaji separate. I have already submitted.
Dhemaji, DC has given that OBC certificate. He has given that.
No, wherever he is residing, he can get a certificate there, but the problem is that we need this document.
That
Can I contact them?
we can contact with Dhemaji and Lakhimpur district. My friend will.
No, this is the one. Lakhimpur one. Lakhimpur Nigeria. Nigeria. No, no, no.
Now, the issue which is required to be examined,
Yes.
the writ petition will come to page 41.
In the writ petition.
Writ petition.
(41). Lordship. The order.
Yes, you'll see in the second paragraph.
I have carefully examined the documents submitted by the proceedee and the evidence adduced by her. And it is found that the proceedee in her deposition in column 5 stated that her father came from Bangladesh and registered his name as Indian citizen in year 1960. But in column 6, she stated that her father was an employee of Assam Oil Limited discharged on 9/7/47. Hence, the statement of proceedee is contradictory and not believable.
You see, that can't be because of the fact that the requirement, the tribunal escaped notice of the tribunal escaped the fact that under Citizenship Act,
Lordship.
what is required is that you must be a resident under section 5
Lordship.
of the Citizenship Act.
Lordship. Before making a person of
7 years, a person of Indian origin who is resident in India for 7 years before making an application.
Lordship. For
So
registration.
at 1947, even if he is there, he went back, came again, it doesn't matter. Because this is 5A, 1A and D.
D.
Now, therefore, he makes an application and then he gets a certificate.
Lordship.
Correct. So this past could not have been ground to
Reject.
to reject it. And number 2, he has a document of big boy that is in the next. That is also annexed and proved. That is at page 24 of the writ petition, Exhibit 3.
Lordship. Lordship.
So thereafter, whatever is there, it is period of service from 1943 to 1944. He worked for a year, discharged due to staff reduction. Correct.
Lordship.
Then maybe he went back, he came again, and then he made a
Registration.
registration. Now, the other point which is involved is, notwithstanding that the petitioner has died, if he is a citizen of India, because of the lack of document, he can be declared to be a foreigner.
It cannot.
So therefore, even though the person has died, we intend to continue to
Be a citizen of India.
without treating it as awaited. Would like to take up the issue.
Lordship.
Because it's not the fact that steps were not taken. Even we are directed, but the records are not coming.
Lordship.
And nobody is saying that this is a fake document.
Proved in original also.
And proved in original.
Proved in original.
So once a person has exhibited the document, then to discard it. But
One
whether
try we can make from the district of Lakhimpur and Dhemaji, one try we can make.
Mr. Sharma, you
One-
have to do it. Mr. Roy cannot.
Yes, Lordship. From Lakhimpur, I can try. Lordship.
Just try to do it.
No.
And on the next date, we'll examine how to proceed in the matter despite the report of death.
Lordship, actually, our communication is go to the concerned SP, but again, SP has communicated it to concerned district commissioner office. So I think
But
Lordship,
if I-
he will-
Mr. Sharma, if he does,
will
it'll be easier.
Directly.
directly.
That's why we pointed out to Mr. Sharma.
You do put really good.
You see, at those point of time, this big boy was under the British control.
Yeah.
So they bought laborers from here and there,
Yes, sir.
and he worked here. Maybe when he does not have work, he went back to Bangladesh, we don't know. But the fact is that he registered himself here. He thus became a citizen under Section 5. Therefore, we are concerned if a person has been declared to be an Indian under Section 5
Yeah.
and he has proved the document, whether then this would be a valid ground to reject. Had he not been able to prove what the names do not match, then there's something else.
No, sir.
It's not a fake document.
Deputy Commissioner. Wow.
If otherwise the evidence does not match, we may reject this also.
First.
If the evidence otherwise do not match, this can also be rejected, but there it is a. None appears on call for the petitioner. However, all the respondents are represented. Next, pursuant to the order passed on 19/1/2026. The Mr. G. Sharma, Runner Standing Counsel for the FT and Border Matters, has produced a bunch of documents appended to written instructions dated 19/2/2026, received from the Senior Superintendent of Police, Dhemaji. Amongst others, stating that the original records of registration of citizenship in respect of Bishambar, Biswambar, Bishambar Devnath, could not be located. Next paragraph. From the contents of the said citizenship registration certificate, it appears that the address provided of the said Bishambar Devnath is Basti. Topla Basti, Toplabasti, one word.
Basti, PS Digboy, Lakhimpur. Full stop. It appears to the court that in the year 1960, Digboy was a part of Lakhimpur, the undivided Lakhimpur district.
Lakhimpur district.
Thereafter, the Lakhimpur district were divided and for the and the Digboy police station came within the jurisdiction of Tinsukia district. Tinsukia district was thereafter bifurcated and bifurcated and Dibrugarh district was subsequently created. Full stop. The signatory of the said document is the the sub-deputy collector, Tinsukia. Therefore, the concerned record, therefore, it is possible that the concerned record may be available in the office of the deputy commissioner, Lakhimpur.
Perhaps now they are in Dhemaji Mela. Earlier, I have submitted one documents regarding that OBC certificate.
No. This registration certificate must be with the deputy commissioner. Now that has come up. Therefore, we are saying that this document at page 34, that has to be with them. It's not an OBC certificate. Now, in this certificate. Court is inclined to request the learned to request Mr. P. Sharma, an additional senior government advocate, communicate an order of this court to the district collector, Lakhimpur, together with a photocopy of the citizenship registration certificate dated 3/5/1960, certain as to whether the said record is available in the office of the district commissioner from Lakhimpur. Next paragraph. The learned standing person for the NP and border matters has submitted that along with the said instructions dated 19/2/2026, a death certificate of Srimati Bakuli Devnath on the petitioner in this case has been enclosed, which reveals that the date of death was 16/10/2025. Next paragraph. This aspect should be dealt with on the next date of listing. Next paragraph. List the matter again on give a date after 5 weeks. Before that, you say that the instructions along with the enclosures are retained on record. As produced, retained on record.
Yes.
You just tell the court master, they will give it to you that photocopy if you think of that. No,
I have. It will.
our orders will get it.
Yeah.
30th of March.
Ultimate.
What because this, you are including this access for CGC.
Item 4 for motion.
Yes. Yes.
This is the original copy of the letter. Now I have to Google.
সামাজিক ভাবে আপনি লক্ষ্মীপুর মই কালেক্ট করে দিম আপনার মানে আপনি অফিসত অফিসত খবর কৰিলে পাব মই আপোনাক ইনষ্ট্ৰাকশ্যনৰ কপি এটা দি আছো হবে স্যার হোয়াটসঅ্যাপত দি দিম স্যার লাগবে ঠিক আছে ট্রান্সফার
So from the delivery of order, there is a delay of about 79 months. There is wrong on our part, the mentioning the word verifies. Try file on affidavit, clarifying that matter. And moreover, as per Honorable Supreme Court judgment, my lord, we are getting 2 years exemption, my lord. That judgment is there, my lord. Yeah. 2 years will be exempted because of coronavirus, judgment is there. It is a 15/3/2022 till 28/2/2022. That 2 periods is to be exempted. My lord, I calculate from the date of judgment. From the date of judgment.
By filing this writ petition on 19/11/2025. Based on P 2026 for delivery orders. Okay. For delivery order, 7th of March.
7.
You'll have to take some time. There's too many cases piled up.
For final order.
No, for consideration of this issue of delay in latches.
Format. I found that our judgment is 11/2018 and it was exempted from 15/3/2020 to 8/2022.
We are reading.
Will be, it will cover in my case or not, it is to be,
You're reading where?
my lord. In the judgment, Supreme Court judgment, last page, my lord. It was from 15/3/2022 to shall be excluded. But whether it is applicable in my case or not, my lord. Then my judgment is 11/2018.
Not 18, 19.
Oh, it's 19, my lord.
Please remember on the date, on the day's date, please remember to take this copy of the order. We may forget. The other members of the, you may not have time to take up any other matter. This had be,
Well, item number 7, can it be fixed next Tuesday? Monday or Tuesday, madam, it's a motion. Your lordship's judgment was there for inquiry and ultimately there was no inquiry and again, madam, the LBO report shows something. Item number 7.
six, seven,
Page 79, your lordship judgment. Where your lordship as operative portion has directed. Para 7, page 81. Your lordship judgment starts at page 79. Relevant para 7, page 81. Seven.
Notice my issue, my lord, is a decision 2026. Open space, my lord, 65. What are the 28/11/2025? Yes, SP border Kukrajar.
Hello, please.
Item 5.
Stated opinion is Lordship.
(25/11/2013), Lordship. This is a case, Lordship, where there is no. But it will take time, Lordship. Lordship. Condition.
Item 7.
May it please your lordship. My lord, I take your lordship to page 79, your lordship judgment. And the operative portion is at page 81, para 7. Page 81, para 7. Then, my lord, we approach the trial court. Trial court at page 83 passed that order on 19/8/25. The relevant portion, my lord, that they have directed that the government pleader may take necessary instruction from the referral authority, apprise the tribunal as regards the content of the application, number 46/25. Then, my lord, at page 85, on 11/9, your lordship may turn relevant portion, page 86, last. The petitioners has already filed written statement and contents of the written statement is clearly perused. To find in para 11 of the written statement, the issue was raised. Considering the materials as above, the tribunal is of the view that a preliminary issue as regards availability grounds against the petitioner, as raised by the petitioner herself, needs further consideration. As such, the referral authority may conduct a clear inquiry on the basis of documents produced to be produced before the said authority as regards to the availability of the prima facie ground against the petitioner, framing the basis of a clear suspect. Then, my lord, the court at page 88 passed that order, saying that there were two, one is Sabera and another is Saera. And there was an interchange between documents in two courts. So there was ultimately no inquiry held, and my lord, we have been directed to file evidence. Though there was a judgment from this court for, on the basis of the documents that we have furnished, there should be an inquiry. Inquiry held on 11/2/2025, but 11/12/2025 at page 88. Not furnished to us. Not furnished to us.
Yes.
Lordship.
Yes.
My lord.
This inquiry report is lordship, perhaps it was collected by the tribunal lordship, so is APP. Oh. Okay, yes, lord.
My prayer, my lord, because the next date has been fixed on 10th March. 10th March, prior to that. Or if not, then, my lord, at least this proceeding, till it is decided that order 14/2 application. It is from Gauhati, my lord. রিপোর্টেশন সব হবে, রেকর্ড যখন হবে তখন হবে।
And so this is subsequently, as per order dated, as per order dated 23/12/2025, comma, inquiry report stated to have been submitted on 10/12/2025 by the inquiry officer,
11-12 madam.
10/12.
There are two dates given.
What's that? Okay, 11,
One third, fourth line, 11-12, fifth line, 10-12.
11/12/2025, and in the order date 23/12/25, there is a reference to two inquiry reports dated 11/12/2025 and 10/12/2025. Full stop. The court is inclined to call for the not stop. Next paragraph. The learned counsel for the petitioner submitted that as the order dated 23/12/2025 is not in accordance, is not in compliance with the directions contained in paragraph 7 of the order dated 14/8/2025, passed in WBC 3506 of 2025. The petitioner, by filing this writ petition in Article 236 of the Constitution of India, has prayed for setting aside of the order dated 23/12/2025. And for other consequential reliefs. Next, issue notice returnable on 9/3/2020. We'll put it on Saturday, as fixed matters,
Madam.
on 7/3/2026.
Okay.
Requisite extra copies of the writ petition is out on the learned CGC State and Department Council in course of the day. Next paragraph. The
Petition is there.
next paragraph, as it is submitted that the next date of the proceeding is fixed on 10/3/2027. As 26, considering the urgency, the court is inclined to request the learned member from Partners Tribunal number 4th, Counter Metro Gauhati, that on receipt of a certified copy of this order, the said learned tribunal shall transmit a scanned copy of the inquiry report referred to in its order dated 23/12/2025, either to the registry of this court or to Mr. G. Sharma, Lanet, standing counsel for the FT, Border Matters and NRC. Mr. Sharma, mobile number you can communicate with the tribunal. Is your mobile number?
Yes.
You don't want to put it on the record, the mobile number, it comes into public domain. That's right.
Lordship.
Mr. Accordingly, we request the learned standing counsel for the FT Border Matters and NRC to communicate his mobile number to the learned member from our Foreigners Tribunal number 4, Campo Metro Party, so as to enable transmission of the said report to WhatsApp or any other electronic mode, or being produced on the next date of listing, like that. The petitioner shall produce a certified copy of the order before the learned member, Foreigners Tribunal 4, Campo Metro Party,
Order commission by the year. Order commission by the year.
within 3 working days.
Hmm.
Within
Hmm.
3 working days.
Monday.
You shall also provide a photocopy of the order to Mr. G. Sharma, Lanet, standing counsel for the FT Border Matters and NRC. Next one is from 7/3/20, please.
My lord, I'm sorry to say one thing, but at page 89, there was a letter dated 22/12/25, which was kept on record. Can that be called upon also, my lord? That is very,
Where is that?
page 89, last, in that order dated 23/12/25. The letter dated 22/12/25 is therefore kept in the record. It says the reference is therefore fixed for further order till the exchange.
No, that letter would be a forwarding letter only. What does it say?
That it's all about the exchange of two courts.
Another letter addressed to so-and-so has been furnished to travel is received and is requested to correct the case record by making the exchange of LBO report. Okay. Here, page 88, the 2 dates are there, page 88. Same page down below is another letter. You, in the top, you add this. Inquiry report so and so. Full stop, they said order dated 23/12/2025 also refers to receipt of another letter dated 22/12/2025. By which the learned tribunal was requested to correct the case records, making the exchange of LBO report of Sahira Begum with the LBO report of Sabira Begum. Will you call this? This also will be called, along with the letter dated 22/12/2025, referred to in the order dated 23/12/2025. But what appears is that there's a wrong exchange of LBO reports into files.
Yes.
And therefore you are a proceeding. That's what appears now.
But, my lord, I will place the next day.
Okay.
The documents that we have placed before the authority, the inquiry officer in pursuance to the application, those documents will show that I am not a foreign alert. I was.
Whatever be, that will be the domain of the tribunal, not for us. Any other matters? Yes,
Item number 8, motion, Lordship.
okay, 8 is also a motion. What is the date of opinion?
Opinion is 31/3/2023, Lordship. Thereafter, we have final and review, Lordship. It is of 28/1/2026, Lordship.
28/1/26.
26, Lordship, Annexure K, page 60, Lordship. Opinion
Mr.
31/3/23.
Bodole and counsel for the petitioner. Opinion is at page
Page 53, Annexure J, Lordship.
53. Opinion dated, page 53, opinion dated 31/3/2023. As well as the review order,
Lordship, page 60, Annexure K, Lordship.
as well as order dated 28/1/2026,
Lordship.
page 60, past influential. So stop by the opinion, first would be opinion, huh? By the said opinion, the petitioner was declared to be a foreigner of post 25/3/1971. And by the order dated 28/1/2026, comma, the review petition were dismissed. Notice 4 weeks of the records will give bail of this 5,000 to the satisfaction of
Superintendent of Police, Border, Lordship, Vishwanath.
Shona. In distance. Please talk for 4 weeks on this.
Review has been filed, Lordship, after 2 years of the opinion, Lordship.
Whatever be, but now since the order is of 26/1,
Lordship.
give him bail for the time being.
Lordship.
That was entertained.
Lordship.
And do anything. Yes, supplementary
Motion.
Oblige, your Lordship.
supplementary motion, item 17,
Item 17.
is there, item 18,
Yes. Date of judgment, Lordship, 29/11/2025.
29/11/25.
Yes,
Page number,
56, Lordship.
six. Mr. Mohammed A. Ali, and counsel for the petitioner, and so and so for the respondents. Opinion, page number
56, Lordship, operative portion at 57.
56.
6.
Dated 29/11/2025, passed by so and so. Same, give bail of this 5,000 to the satisfaction of
Police Commissioner, Kamrup Metro.
DCP border.
15. Whether he's a party, just take it up.
No.
Okay.
Yes, Lordship. DCP border.
Deputy
City
Commissioner of
Guard.
Police, Border, Kamrup Metro Coffee. And what is the other matter? Item 17. Seventy-seven 25. Show the presence of Mr. J.M. Sullivan and counsel for the petitioner. Counsel for the respondents. Opinion is at page 17/7/2025. Case 73. Passed by so and so and so and so. Here also, notice it remain 4 weeks. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border,
Bojali.
Bojali. Looking at the